Hello, this is John Milburn for Laws 12067, Environmental Law. This is week 7 of Term 3, 2017, which is now moving into 2018. This is a recorded session in relation to the content of our reading for week 7, which is all about Chapter 11 of Bates' textbook, Environmental Impact Assessment. Now, we have a lot of material available for you already, so I will try to make this recording relatively short. One thing that I do want to remind you, though, is the importance of referencing your material and citing your material in the appropriate manner. In that regard, ensure that you follow the guidelines and the rules of the Australian Guide to Legal Citations, the AGLC. What that essentially means is that any reference that you put into your material should be by way of footnote on the page itself. That's not in the body of the text, as per Harvard-style referencing, and not as an endnote. So a footnote, and use the mechanism built into the Word program to make that easy for yourself. A couple of things that I really want you to do: make sure that when you refer to the names of participants in a case, you type the parties' names in italics. And watch the way in which you refer to cases. If you have a volume in the citation, then you use round brackets, and if there's no volume and it's year only, then you use the square brackets when referring to the year of a case being decided. Make sure that you use pinpoint referencing where possible, which is identifying the appropriate page. And when you're referring to a case or legislation, don't include the URL. That's not the appropriate manner. Okay, so environmental impact assessment is a huge part of the process of planning for development of a project. Essentially, it's a matter of putting in procedures and systems in place to ensure compliance with legal requirements. It is a critical step in the process. Bates describes regulation as the cornerstone of environmental law, and that's evident when it comes to dealing with environmental impact assessment, because it's a very important component of the regulation of planning for projects and development in environmental law. So the purpose of environmental impact assessment is really quite simple: provide information, enable an analysis or an assessment to be undertaken by the appropriate decision makers, particularly the regulators, to make informed and rational decisions. And when doing that, the decision makers need to take into account the public interest. But remember, the environmental assessment is not the decision. So that means that there is plenty of opportunity for lawyers to argue about what the expert reports, which generally constitute the environmental assessment, really mean and how they should be used by the regulators, or in a merits appeal situation, by the court in stepping into the shoes of the decision maker. So essentially, environmental assessment involves investigation and assessment, and then potentially arguing over the importance of various findings in the context of a development application, and more relevantly, the conditions that might be imposed. So the requirement to undertake environmental assessment and the procedures that then follow from that may be influenced by whether the activity is prescribed or a prescribed class. So think about the involvement of the minister, who may determine the question for requirement for assessment in the exercise of discretion, or the conditions that are likely to have significant impact. But do remember that the environmental impact assessment process does not introduce an environmental veto power into administrative decision making. One thing that's often overlooked is this: when a decision maker needs to consider environmental impact and an assessment, it is only one factor for consideration. Bear in mind that overarching all of this is the concept or the principle of ecologically sustainable development. And when considering ecologically sustainable development, decision makers must give equal weight in the decision-making process to environmental considerations, with those considerations that relate to social matters or economic matters, all of those things inherent in a proposal. So even though we're talking about an environmental impact assessment, the point that I'm making is that it is a much broader concept than simply dealing with pure environmental issues. Social and economic considerations, those human factors, are also extremely important in the process. To properly understand environmental impact assessment, you need to know the procedural steps. That's pretty well catalogued in your book. You'll know that it's a referral process, a screening process, a scoping process. Then there's consultation followed by a review and monitoring of the proposal to ensure that the activity has proceeded appropriately. So I'll leave you to read that and understand those procedural steps, perhaps map it out in a way that makes sense for you. I guess one thing that I haven't covered, and it is important, is determining the question of need for an environmental impact assessment. A proponent of a project has an obligation to refer a proposed activity to the relevant assessing authority to determine whether there is a need for an environmental impact assessment. Now, there are some things that will automatically trigger the requirement for an EIA. So, for example, in Queensland, we look to the certain class of proposal referred to in the State Development and Public Works Organisation Act of 1971. In that regard, particularly look at sections 26 and 29. When it comes to the Commonwealth sphere, we go back to the EPBCA, the Environment Protection and Biodiversity Conservation Act, have a look at the Environment Assessment Manual, which implements Chapter 4 for the EPBCA. To do that, go to the Department of Environment and Energy website, and you'll find a manual that could be very useful. It's also a good resource to refer to in assignments, or if you're mounting arguments in a court situation. It can be very persuasive secondary material to assist you in promoting a certain position or argument. Also, if you go to that website, you'll find the in-house Government Environmental Assessment Manual, which contains a great flowchart, including the EPBCA EIS process. So in week 4, we talked about the Commonwealth's involvement in this process, and you'll recall that the Environment Minister may require involvement in certain matters where an action is a controlled action. In that regard, have a look at section 74 of the EPBCA. And the Minister makes a determination which is subjective. However, the Minister decides whether a project is controlled and does so subjectively, but must apply the correct test when doing so. I'm sure that you've picked up this important point. When it comes to the assessment process, there is a consistency with principles of avoiding duplication of process involving the states and Commonwealth, and that's regulated through the bilateral agreement regime between the states and Commonwealth. And the purpose is quite simple: avoid the duplication of environmental assessment. So we may find that in a particular project, both the Commonwealth and states are involved in the decision-making process, but rather than have both undertake separate EIS proposals, or assessments rather, EIA assessments, they will work cooperatively together through the bilateral agreement regime. Now, if it's Queensland state-based environmental assessment, remember that there are 3 distinct systems for environmental impact assessment. I've already mentioned the State Development and Public Works Organisation Act. To that, and that's part 4, to that you can add the Environment Protection Act and the Planning Act 2016. So in each of those processes, an environmental impact statement is prepared by the project proponent in accordance with the terms of reference determined by the relevant executive agency. So the terms of reference is a very important document. You'll see that in your second assessment piece, where I require you to look at the terms of reference in the context of a development proposal. So the important part generally will be the role of, in the Queensland proponent, the Queensland situation, the role of the Coordinator General, which is constituted under the State Development and Public Works Organisation Act. The Coordinator General has certain matters that are relevant for determining whether a project should be declared a coordinated project, and prior to that, for terminology purposes, you may read about significant projects. That was what coordinated projects were called prior to December 2012. So you'll read about the State Coordinator General having significant powers, dealing with managing major infrastructure projects, making a declaration that a project is a coordinated project, coordinating the EIA process, and dealing with other issues such as compulsory acquisition of land. So the Act gives the Coordinator General considerable power, the power to step in when state government departments, local governments, or other local bodies fail to make a decision in a timely manner. So read about coordinated projects under the auspices of the SDPWO Act 1971, and you'll see that there's a significant amount of power given to the coordinating to the Coordinator General under a coordinated project. All right, so in making the decisions, the Coordinator General has requirements to do so in a particularly timely manner. So you'll read all about that when you're dealing with current projects, such as the Townsville Port Expansion Project, and you'll have a look at that through the Coordinator General's website if you wish. Okay, so that's one, under the State Works and Public Organisation Act. I mentioned the Environmental Protection Act. Have a look at section 40 in that regard, which deals with the process function for environmental impact assessment. And there are 6 critical functions, and you can read about that by looking at the Act. But remember, of course, it's not just a matter of determining whether there are adverse environmental impacts. Again, there is an emphasis on considering beneficial environmental, economic, and social impacts when considering an EIS under the Environment Protection Act. There may be some trigger criteria that relate to that Act as well. And then finally, have a look at the Planning Act, which was formerly the Sustainable Planning Act. All right, well, thank you for bearing with me through that presentation. I do hope that you're well advanced in your second assessment piece. All the best for the new year, and we'll see you again live, I think on Tuesday, the 9th of January. All the best.